The Supreme Court is about to end the era of states telling you where you can and cannot carry your legally permitted firearm. A ruling expected by June 2026 could permanently destroy Hawaii's law and every similar law in New York, California, Maryland, and New Jersey along with it. This is Wolford versus Lopez, and based on what the justices said during oral arguments on January 20th, 2026, the anti-gun states are about to lose badly. If you have a concealed carry permit anywhere in America, this ruling directly affects your rights starting this summer. I am going to break down exactly what happened at the Supreme Court, what the justices said, and what this means for every single gun owner and permit holder across the entire country. Stay with me because this is enormous. Here is what Hawaii's law does right now to gun owners. Even if you legally obtained a concealed carry permit, you cannot carry your firearm on any private property open to the public unless the owner gives you explicit written or verbal permission first. Every single time. That means restaurants, gas stations, grocery stores, shopping malls, parking lots, hotels, anywhere privately owned but open to the public. Gun owners with a concealed carry permit who stop for gas with a pistol in the glove compartment risk a year in prison if they fail to obtain the gas station owner's unambiguous consent. NBC News. Think about how absurd that is in practice. You are a law-abiding permit holder. You legally carry your firearm for self-defense. But before entering any business in Hawaii, you must find an employee, ask permission, and wait for a response or leave your gun behind entirely. The challengers told the justices that the restriction requires licensees to leave their firearms at home whenever they go out in public if there is any chance of visiting private property open to the public. NBC News. That is not a permit. That is a permission slip that makes carry practically impossible. Gun rights advocates called this the vampire rule, because just like a vampire in folklore cannot enter a home without being invited, gun owners in Hawaii cannot enter any private property without expressed permission. The Supreme Court justices found that comparison very telling during arguments. Oral arguments happened on January 20th, 2026, and the justices made their skepticism of Hawaii's law crystal clear. The majority of justices questioned the logic behind Hawaii's ban and the property owner consent provision, which they labeled the vampire rule. SCOTUS blog. The anti-gun side just had no good answers. Chief Justice John Roberts directly questioned Hawaii's lawyer on how the property owner consent rule created conflicts with both the First and Second Amendments. SCOTUS blog. When the Chief Justice is pushing back that hard, it is a very strong signal about which way the court is leaning. The DOJ argued that Hawaii's law singles out the carrying of firearms for discriminatory treatment, requires owners who open their property to the public to satisfy a special clear statement rule for firearms, and contains exemptions that make sense only if Hawaii were trying to limit arms bearing to favored groups. Duke Center for Firearms Law. Legal experts closely following the case believe the court will strike down the limitation on concealed carry, with the majority likely ruling that Hawaii's consent requirement is not a legitimate pattern of a historical regulation. Duke Center for Firearms Law. The Bruin Standard simply does not support what Hawaii is doing. The core constitutional argument is straightforward. In 2022, the Supreme Court ruled in Bruin that the Second Amendment protects the right to carry a firearm outside the home for self-defense. Hawaii responded to that ruling by passing this new law that made public carry practically impossible. Anyway, Hawaii loosened its licensing restrictions after Bruin, but simultaneously enacted a new restriction that effectively nullifies those licenses and prevents public carry, specifically making it a crime for licensees to carry firearms on private property open to the public, the very places where licensees would go in their daily lives. Duke Center for Firearms Law. The plaintiffs argue there is zero historical tradition of laws broadly banning law-abiding citizens from carrying firearms on private property open to the public without getting expressed permission first. The Court of Appeals relied on a 1771 New Jersey law that barred poaching on closed lands, on which the challengers correctly called a trespass law, not an analog to Hawaii's sweeping firearms ban. NBC News. Under the Bruin Standard, gun laws must match America's historical tradition of firearm regulation. Hawaii cannot point to a single valid founding-era law that required permit holders to ask permission before entering a business with their legally carried firearm. The historical record simply does not exist. This case goes far beyond Hawaii. Every other state with a similar rule, including California, Maryland, New Jersey, and New York, already saw it invalidated by a federal appellate court applying Bruin's historical standard. Moyer, a Supreme Court ruling here, permanently settles the issue nationwide. New York passed a sweeping new gun law directly in response to the Bruin decision. It created massive new lists of sensitive places where carry is banned, and imposed the same kind of property owner consent requirements. A ruling against Hawaii directly threatens every element of New York's post-Bruin gun law. Maryland, New Jersey, California, and Illinois all passed similar laws after Bruin, trying to restrict where permit holders can carry. The Fourth Circuit already struck down key parts of Maryland's law, finding that Maryland's rule would effectively declare most public places gun-free zones and stretch the sensitive places doctrine too far. SCOTUS blog. A Supreme Court ruling in Woolford v. Lopez does not just affect Hawaii. It sends a binding, permanent message to every anti-gun state in America. You cannot use private property rules to eliminate the constitutional right to carry that the Supreme Court already recognized in Bruin. Based on everything that happened during oral arguments, here is what the ruling will most likely look like. The Supreme Court will strike down Hawaii's consent requirement as unconstitutional. There is simply no historical tradition supporting it, and the justices made their skepticism overwhelmingly clear during arguments. The ruling is expected to come down by late June 2026, when the court typically releases its most significant decisions. Duke Center for Firearms Law. When it drops, it will immediately invalidate similar laws across every state that tried to use property owner consent rules to eliminate public carry rights after Bruin. The ruling may also address what counts as a sensitive place where guns can legitimately be banned. The court could draw a clear line between genuinely sensitive locations like courthouses and schools and ordinary public businesses like restaurants, stores, and gas stations, where carry must be permitted. This will be one of the most significant Second Amendment decisions since Bruin itself in 2022. It will permanently define the boundaries of where law-abiding permit holders can carry across the entire country and shut down the most creative anti-gun workarounds states have tried to implement. First, know your state's current laws right now. Even before this ruling drops, many states already allow permit holders to carry in most private businesses unless the owner explicitly posts a no firearms sign. Know exactly where you stand legally in your specific state today. Second, watch for the ruling in June 2026. The moment the Supreme Court issues its decision in Woolford v. Lopez, the entire landscape of carry law changes immediately. I will cover the ruling in full detail the moment it drops right here on this channel. Third, if you live in Hawaii, New York, Maryland, California, or any state with similar consent requirements, document every instance where you're forced to leave your firearm behind due to these laws. That documentation matters for ongoing legal challenges in future cases in your state. Fourth, support the organizations fighting this case. The gun rights groups that brought this challenge to the Supreme Court spent years and significant resources getting here. The Firearms Policy Coalition and Second Amendment Foundation need continued financial support to keep winning these battles. Woolford v. Lopez is the most important concealed carry case since Bruin. It will decide whether states can use clever legal tricks to eliminate your right to carry in public even after you obtained a legal permit. The ruling comes by June 2026, and it is going to be massive. The Supreme Court already told America in 2022 that you have a right to carry outside your home. Now, they are about to tell anti gun states they cannot simply pass new laws to take that right away through the back door. This is a fight gun owners are winning. If this breakdown helped you understand what is coming, share it with every gun owner you know. Subscribe to Gun and Gavel, hit the notification bell so you get the full ruling breakdown the moment it drops. Drop a comment. Do you think the Supreme Court will fully strike down Hawaii's law? I want to hear yours.